Hi, and welcome to Medmarc's webinar series. Today's presentation is titled Life Science Claims 2022, Redefining Normalcy. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, thank you for joining us. Jennifer Heis is a partner in the Cincinnati office of Ulmer Berne. Jennifer has more than 20 years of experience defending manufacturers and distributors of pharmaceutical products and dietary supplements. She has represented her clients in complex litigation, including multi-district litigation and consolidated state court proceedings, as well as individual cases throughout the country. Our next presenter, Lauren Hulbert, joined Medmarc in August 2005. Lauren is responsible for investigating coverage and liability, managing reserves and litigation, monitoring outside service providers, negotiating settlements, and maintaining good client relations. Due to her varied experience, she has handled claims of increasing complexity and severity in her time at Medmarc. And our last presenter is Andy Hall. Andy joined Medmarc in 2017 as a senior claims examiner. He's responsible for claims investigation, coverage analysis, managing reserves, negotiating settlements, monitoring defense counsel activities, and maintaining good client relations. Andy also works in the product development team, where he assists with drafting language for our new products. And with that, I am pleased to turn things over to Andy.
Hi, everybody. I'm going to quickly go over our agenda. As you can see, we have a lot to cover here. We're going to get to the what I'd call the meat and potatoes part of what we do here. So the key developments, the excessive verdicts and factors, and the looking forward to 2023. Before that, Lauren and I wanted to cover some things that we've been seeing in the industry and some emerging technologies and how we think they might start impacting all of us in the claims and litigation world. So without further ado, let's move into the first industry trend that we're going to discuss here today, which is talent shortages. So we're going to start with an audience participation question. We're going to make this a little bit interactive for everybody today. And so the first question we have is, in 2022, has it taken your company or your clients longer to fill open positions? All right, let's give that about 10 more seconds and then I'll close it out. All right, so I'm going to end the poll, and then this should share it with everybody. And it's a result that I'm not terribly surprised to see. 92% of you have seen that it's more difficult to fill open positions in 2022. For the 8% of you that it hasn't been, congratulations. I think you're sort of the distinct minority in this job market. So, well, the reason we wanted to cover this is an acutely, sorry, let me go back. Slide. Okay, sorry about that. Problematic thing for the life science industry. So the life science industry has had the same issues as everybody else. You know, the Great Resignation being the biggest one of those. But in addition to that, it's seen a massive industry growth compared to the rest of the job market, and we'll talk about that. And this is really an issue that predates COVID, as I say in my slide, and it exists across all educational spectrums and locations. So the next slide, I'll show you data from the Biotechnology Education Foundation in Massachusetts for the 10-year period ending right around the pandemic. And you can see all right, next slide. All right, that the demand across all educational levels has increased at least 120% to 140%. And except for the bachelor's degree level, the labor market is the same. So that sort of becomes a problem when you have a huge demand increase and you don't have the appropriate number of people to fill those positions. Another reason for this, and I should have said this on the prior slide, so I apologize for that, and we'll get into this a little bit more, is that the life sciences industry has seen that some of the skills that it requires are ones that it's kind of it's shopping or hiring people in new talent pools. And what I mean by that is data and technology and things that are not life science specific are big reasons for the growth in the life sciences industry. So you're competing with a whole range of other industries to get candidates for those jobs. So this chart I'll go over real quickly. If you look at the green line, that's the U.S. employment levels or occupations, number of jobs for the United States as a whole. And then the black line is in the life science research world. So you can see that this is steadily increased and far outpaces the rest of the economy. You can, next slide, similar kind of proposition, unemployment rates. The unemployment rate in the life science industry is, it's hard to tell, but it's a little bit above 0.5%. Which is pretty amazing. That's basically non-existent unemployment rates. And it's well below the about between 3 to 3.5% for the US job market as a whole. And this was a chart made in the summer of 2022, so it's pretty current. So further reasons that illustrate why the life science industry employment base is increasing and the jobs are hard to fill. In 2020, so the beginning of the pandemic, life science, the employment base increased by 1.4%, while everybody else had a 5% loss. And this is really why it kind of merges into my world and the claims and the litigation world. It takes 105 days on average to fill a non-executive position in the life sciences sector. And that's a cost of $500 a day per job in terms of filling and loss of not being able to fill these positions. So these charts and stats are all kind of interesting, but why does it matter on the claims perspective? So let me go over a few reasons. These are the ones that I could kind of come up with and why not being able to fill positions or fill positions with the candidates that you might want could be problematic and lead to claims and litigation. So the first would be vacancies and positions critical to design and manufacturing. So the example that I gave here on this is you use a chemical component as part of your product. The person who's responsible for inspecting the component when it comes in, when you take delivery of it, leaves. And either there's nobody there to make that inspection or somebody who's not used to doing that or unqualified to do that accepts the product and the bad component part is put into your product. And that could lead to really any number of claims, an economic loss claim, a BI claim, or a PD claim. Kind of a similar subset here is employees taking on additional responsibilities. So, I won't go through that example because it's essentially the same one I just gave you. But as people add on responsibilities, it stretches their time and may stretch them into areas where they're not as naturally as expert, which can lead to problems, kind of, again, using my example of inspecting the component parts. Then the last part of this that I'll talk about is if you can't fill a position, you may have to resort to using underqualified or inexperienced people filling vacancies. And this example here sort of relates to a real world example. So for example, you have a new employee, your product is a birth control product. At least historically, that's a product that needs to be, the pills need to be put in a certain order for the drug to work. You have a new person who's unqualified or inexperienced or learning the job. They mix up the order, the pills go out, and I think the consequences of that are fairly obvious. So at this point, we will turn it over to Lauren, who's going to talk to us about supply chain issues.
Thanks, Andy. So just like the last section, we are going to start out again with another audience participation question. So the question is, have you or your insureds or your clients experienced any of the below in 2022? So it's delays from suppliers, increased prices on component parts, inconsistent demands for products, and talent and labor shortages. Good.
Okay, let's give this a few more seconds and we close it out.
Are we sharing?
It was sharing, not
Okay.
go through. Okay.
Okay, well, so like everybody can see now, clearly, everybody seems to have a little bit of experience with all of these things: delays from suppliers, increased prices on component parts, inconsistent demands then as a result of the same. These are all reasons for the supply chain issues that have occurred over this last year. And as the survey that was originally, this is based off of a survey from Farrell Lee, and their survey, which was actually from during the pandemic, the survey said that 50% of companies who suffer these kinds of problems had to then go out and find new suppliers. There's actually a Deloitte article that came out more recently that increases that number to 75%. So you can definitely see how each of these things kind of affects productivity. Next slide. So again, similar to what the prior slides, this is just an example of kind of what the readings are with supply chain issues as compared to previous readings, and this is pre and post pandemic. The black line represents the average condition, and then the other colors kind of show different segments, January to April of 2022. Next. Andy. Can you go back one? Perfect. Okay. So just like the talent shortages issue, supply chain issues definitely have been across all industries, not necessarily just the life sciences sector. We've seen it, personally in automotive and different things. Specific to our group, it is the average that you kind of see here, looking at the standard deviation between March and April of 2022 across the world there's zero, right? Zero means that there's nothing, there's no change. But it says, but when you look at the chart, that things that are above zero are exerting pressure on the global supply chain. And those big negatives included things like delivery times, a lot of the things that are coming from overseas with delayed shipments, increased air freight costs from the US to Asia, and delivery times as well as in Europe. In addition, some of these same issues also arise for negative reasons, which are the geopolitical tensions. So the war going on in Ukraine, as well as the continued COVID restrictions and lockdowns that are in China. Let's see, two more. Okay, so specific to life sciences companies, interestingly enough, this was a survey taken last year amongst CFOs as to what exactly their worries were in 2022 regarding supply chain issues. And as you can see, some of these things that we talked about in the poll are the same worries that these CFOs had. Interestingly enough, the worries for US companies were not seen to be as great as those for global companies. And okay, that's fine. So the same kinds of issues, right, can come up with supply chain issues, and some of these things I think we've seen before, but I think the supply chain challenges can exacerbate some of these problems. So, if you can't get if you're a company that provides services for medical devices, and you're not able to procure the parts that are needed in order to fix something, failure to be able to fix the issue at hand can then cause injury or property damage just as a result of timing, because people are still using these products. It's broken, but it's not broken enough to not use it is kind of what's heard. At the same time, the other issue that we have are, manufacturers can be forced to then find alternative supply chain solutions. And then they may, as a result, not have the same quality given those other suppliers. And the example here is going to be the precious metal shortages. Half of the medical devices on the market have semiconductors, and those are made of platinum and palladium, which come from, China and Russia for the most part. Failure to manage those supply chain issues could result in then non-conformities with the medical devices. And those things usually end up with manufacturing issues, design issues, and ultimately could result in injury or damage to people's body or property. Next. So every year we like to give a little bit of a hint of Medmarc. This is a slide that goes back about 10 years, and it really just kind of gives a trend by quarter of kind of the number of new claims that we've gotten. And you can definitely see, I don't have access to the mouse, but you can definitely see based off of the 2020 year that when COVID hit, things changed significantly. While it looks like, as compared to some of the earlier years, claims have definitely come in more as a result. We're still not necessarily as, as it was back in 2014 to 2015 or 2016. Next. And then this is kind of we put a similar slide up to this last year. These are the claim payment trends. So when you look at the average total paid, year-to-date total paid on claims that have payments, to be clear, there's no necessarily real trend here to see either as a result of, supply chain issues or talent shortages. But those could be things that affects some of these numbers going forward. And now I'm going to hand it back to Andy to talk about some emerging technologies.
Thanks, Lauren. I'm going to go into emerging technologies here. So the first thing that I'm going to do is talk to you about augmented reality. And far be it from me to offer up detailed technical descriptions of these types of technologies. So I kind of cheated a little bit and I found videos. So this video is about a minute, so I'm going to let it play and then I'll talk to you a little bit more about augmented reality and what it's going to mean in the claims world. All right, so I guess I need to thank the medical futurist there for giving you a description of augmented reality, but this is really a fairly neat thing and it's already being deployed pretty extensively in the life sciences sector, and I think is going to be even more so moving forward. Surgery is sort of one of the biggest areas where this is already developed, as you saw in the video. They're using scans and things like that to allow doctors to walk through a patient's organ before surgery. And this didn't make my slide, but I thought it was very interesting. In 2020, Johns Hopkins did the first AR-based surgeries. They were both spinal, so one was a fusion and one was removing a tumor. And they used the AR to ensure proper placement of the spinal screws during the fusion surgery, and kind of do that in a more efficient way than placing it and looking at the scan to make sure that the placement was proper. They also are talking about Google Glass or something like that being used by surgeons so they can put vitals and important patient data in the surgeon's field of view so they don't have to split focus while they're in surgery. Medical training is another area where this is going to be used, and that's fairly obvious. If you can use AR to help teach anatomy and things like that, that's, I think, probably a more efficient way to do it. And I thought this was fairly interesting. In pharmaceuticals, they're discussing using AR to help patients understand what the drug is and what it's doing in the body in a more interactive visual way than just giving them a pamphlet or a bunch of instructions that they may or may not actually read. And then the last little thing I'm going to mention, this will be pretty quick. They've also kind of used this in a similar way to kind of the IKEA catalog. Here's a medical device. How is it going to fit? How do we place it? So that's a way where it's being used at this point. So there's really two levels here on the claim side. Let me skip to my next slide real quick. The first is what I call the non-life science possibility, and the second is the life science possibility. So augmented reality, in terms of litigation, it's really been in the video game world, and it's existed. There have been cases on and off really since about the 1980s, and they fall into two main types of injuries. There's a light sensitivity and epilepsy. These claims are largely unsuccessful because there's no evidence that the AR or the video game causes epilepsy. It's really more that some people may have some light sensitivity. But again, these claims haven't really gone anywhere. And the second is motion control injuries. And the example of that would be, I don't know, I guess about 15 years ago, some of you or your kids may have had the Nintendo Wii with the controller, and you can make yourself move on the screen. Really, those motion control injuries are, lack of a better term, you whack your friend in the head accidentally with a controller while you're using it. I mention these because they are things that could theoretically happen with a life science application of this technology, but there's really not anything life science specific. So that will lead me to my second slide on the claims. We'll also get into the life science possibilities. These are the ones that I came up with. And there are really three main categories. Incorrect projection of a scan. So that's really going to do with the surgical part. For example, if the augmented reality takes the CT scan or MRI or whatever is being used and doesn't properly convert it and the screw is placed incorrectly, that could be an obvious claim or litigation. Incomplete, inconsistent, off-label information. I was thinking mostly about the pharmaceutical element there and how the information or the technologies that's being used, you're still going to have to be consistent with what the FDA has approved on there. And then, again, another fairly obvious one, incorrect missing information on the data being projected to a doctor during surgery. The pharmaceutical is sort of off on its own, but these other two, I think, are ones that lead to claims in the future that have an element of, is it user error or is it the AR, right? So what I mean by that is, think about my example with the Google Glass and the surgical information, and the doctor needed to be able to see the patient's blood pressure. That wasn't projected, and then there's some sort of adverse outcome as a result. Is that because the product didn't, the AR didn't put the blood pressure on there? Was it not put in correctly by the surgeon or by the blood pressure cuff or by the person responsible for putting that information in? So I think that these could lead to worlds not dissimilar to what we do these days, where it could be the product, but it could also be user error or some other explanation. So the second technology that I want to talk to you all about is artificial intelligence. Again, far be it for me to explain the technology to you. So I found a 60-second video. Thankfully, all these technologies have 60-second videos that were pretty easy to find on YouTube. So let's listen to this one, and then I'll talk a little bit more. All right. So there are 6 main areas where artificial intelligence is being used in life science. So probably the biggest one would be diagnosis, or the first one anyway, I guess. I think it's the biggest, is diagnosis and disease identification. Where I've seen this most prominently or read about it is in cancer diagnosis and identification. And in fact, I can think of friends that I've known who have had cancer more recently, and the precision and the data that they're taking to identify the precise type of cancer and the treatment, it's pretty amazing. And even in the last 5 years or so, that technology has really improved based upon the AI being able to make predictions about kind of the best course of treatment. The one you may have heard on with the diagnosis and disease identification is IBM Watson Genomics. That's machine learning. And then there are other ones. A Google subsidiary is making one, and they've been applied outside of cancer. So as you see on my slide, central nervous system disorders, macular degeneration. And what I thought was interesting is it's even being used to help treat depression. So personalized medicine is kind of similar to the diagnosis and disease identification, but it's going to be more particular to the patient and their personal data. in making those predictions. IBM Watson Oncology, so another IBM product, is probably the most prominent of these so far. And it's using the data to help design the treatments and predict the best outcomes. So unfortunately, these split onto two slides, but the next two I want to talk about are pharmaceuticals and clinical trials. And the idea here is roughly the same. In the pharmaceutical context, using AI to improve manufacturing processes, make them more efficient, I think is fairly obvious explanation. But they're also talking about using this artificial intelligence to research and design drugs in the most efficient way possible. And so one of the ways we're talking about this is in the clinical trial context, where if the AI can tell you the most likely way to make this drug effectively treat whatever the disease is that they're working on is X, then that's a clinical trial you take. Obviously, nothing's 100% guarantee, so there can be some trial and error still. But the idea being, I think it's something like $2.6 billion to get a drug to market, some astronomical sum to get a drug to market, that if we can eliminate some of the trial and error, the cost to market will go down, which will make it easier for companies to get into this field, and quite frankly, probably to get more drugs to market. So I think that's a really interesting application of this. Then the last two are radiology. They're talking about taking all these different images and putting them in a system and looking at the patient scan and being able to make predictions about healthy tissue, cancerous tissue. There's just a super fast processing power now using artificial intelligence on these versus a radiologist, getting the scan, taking a look at it, examining it, making his conclusions. And then the electronic health records, sort of selfishly, this is something that I hope the way they're talking about this eventually makes it into the litigation field, so we don't have paralegals trying to decipher doctors' handwriting. But what they're talking about here is taking everything, right? So the records are already put in via the computer, the doctor's notes, the nurse's notes, the scans, the pharmaceutical records, putting it all together, having the algorithm translated into a way that's readable and usable to everybody, to create efficiency in health treatments. Right. So two major areas here in terms of claims and litigation for potential. The first is essentially the AI gets the answer wrong. And like I was talking about with augmented reality, I can see this being the algorithm gets it wrong, and then the algorithm is only as good as the data it gets, kind of leading to a user error. I think another subset here with artificial intelligence, kind of going back to the cancer ID and treatment, is what happens if we get lawsuits where they sue the company making the artificial intelligence because the cancer treatment didn't work. Like everything, there's still risk here, and these aren't going to be guarantors that the treatment is going to work. So then you get a question of, is it user error, is it the product, or is it just fate that not everything is going to be successful? This will ultimately, my prediction is this products liability claim, so my next little bullet point, is ultimately going to be resolved conclusively by all the courts as, yes, the artificial intelligence, the algorithms, they do fall under products liability law, but there's still some unanswered questions here. And in a similar vein, there's the insurance coverage piece, which someone who works for an insurance company is interesting to me. As you know, insurance historically, they like tangible physical things, and this is not one of them when you're talking about AI and algorithms and things of that nature. So what do at least the initial coverage cases, what are they going to look like in this regard? And how is policy and language going to change? The subset here, or secondary consideration rather, are privacy considerations, and in particular, Biometric Information Privacy Act claims. Illinois, and they've had this law in the books for quite a while, but I think it's getting much more play in the legal world these days, protects your biometric information. So the life science specific one of these that I found that I thought was interesting is Neutrogena has an app where you take pictures of your face or whatever part of your body that you're looking for their products. They take that information, your biometric data that you provide it, and they say you should use this type of lotion, this type of skin cream, whatever. Well, the biometric information being taken there was apparently, or at least allegedly, being taken without the informed consent of the people using the app, and then was used to improve the algorithm. So they're now facing they call it the Biometric Information Privacy Act. So they're facing a class action on that. That's still pending, so there's not been a resolution. And real quick, because I got to get this over to Jenny, but the last thing I want to get into with the artificial intelligence is there's also a likelihood of lawsuits kind of arguing about essentially like a bias in the algorithm or the artificial intelligence. And in particular, what I was thinking about here was some of you may remember Meta, so that's the parent company to Facebook. They were sued for arguing that their algorithm steered individuals and minors to kind of become addicted to the app. I'm sorry, addicted to their social media products by the likes and what they were putting in their feeds. And so I certainly can see variations of that coming, even with like this Neutrogena app that I'm talking about, right? An allegation that the app only steers you to the most expensive products, and it's not designed with the best interest of the user. So with that, any further delay, I will pass it over to Jenny.
Thanks, Andy. Hopefully everyone can hear me. I'm going to sort of talk about things from the litigation side now. And we'll start with key developments in 2022, including some of the top cases and an update on some of the big MDLs. There we go. So we're going to talk about three top cases. The first one being the Zantac MDL. A huge decision came out just last week in that litigation involving Daubert rulings, and we'll talk about it in more detail. The second one is the City of Huntington versus AmerisourceBergen. That was a bench trial in an opioid case in West Virginia. About a year after the bench trial finished, the judge came out with a decision. And so that was some good news in 2022 about opioids. And finally, the James versus Medtronic case, that is a reasonably good outcome case involving a medical device. So we'll cover those three areas. First, the Zantac case, that is related to an MDL that was created in the year 2020. It is in the Southern District of Florida, assigned to Judge Robin Rosenberg. And the claims there are that NDMA in ranitidine caused cancer. And the NDMA forms in two ways. First, through sort of the natural deterioration of the product, which maybe is accelerated based on storage conditions that are warm or humid, will increase the amount of NDMA in the product. The plaintiffs also allege that NDMA forms in the body through the chemical metabolic process in the body, particularly in patients who have a high nitrogen diet or high nitrate diet, which is one of the things that leads to heartburn, which is why people take Zantac in the first place. So it's sort of a nice theory for them because they can argue that the product is not defective on the shelf, but becomes defective in its design as it's metabolized in the body of the people who use it. So they had that sort of twofold theory of defect. Both sides, the MDL was really focused in this calendar year on general causation, expert testimony. There were depositions. Both sides moved to exclude the other's general causation experts. And like I said, last week on December 6th, Judge Rosenberg came out with a very detailed opinion, 431 pages, excluding all 10 of plaintiffs' general causation experts. And in light of the fact that plaintiffs had no general causation testimony or evidence, she granted summary judgment. The question before the court there really was, is there admissible scientific evidence that Zantac can cause the designated cancers? So there were allegations throughout that MDL about all sorts of cancers being caused by the NDMA in Zantac. The court asked the plaintiffs' steering committee to choose the 10 they were going to focus on. So there were 10 designated cancers for which there were general causation experts set forth. And she excluded all of them and and basically granted summary judgment on all of the claims involving those designated cancers. Some of the opinions that she rejected included those about how Emory Pharma, the toxicology expert, determined the amount of NDMA in ranitidine. There were tons of independent testing done by Emory Pharma and the specific expert identified by the plaintiffs. And the court found that they did not have a reliable method to measure the amount of MDMA in ranitidine. They used chromatography in a way that varied from the two methods that FDA had validated to determine NDMA levels. And they also allowed the lab analysts to use their subjective judgment too much. It wasn't well documented. There were a variety of documentation issues. They weren't all following the same SOPs. And so for all those reasons, the court found those expert opinions regarding the levels of NDMA in the product inadmissible. She also found that the epidemiological evidence lacked widespread support. So that would be the evidence that ranitidine increases the risk of the kinds of designated cancers, that people who took ranitidine for a long period of time had higher rates of cancer or the designated cancers than the rest of the population. And she found that the experts who attempted to show the threshold dose at which ranitidine would cause or could cause cancer in particular individuals also was unreliable. So she really gutted them on many, many levels. Oh, sorry. And I'm still I'm somehow a slide ahead. But in any event, it remains to be seen what will happen next with the litigation. Obviously, it's gutted in the MDL. There are quite a number of state court cases all around the country. And so we will discuss that in a little bit more on a later slide. The second good case, now this is the opioid one, the city of Huntington versus AmerisourceBergen. In that ruling that was after the bench trial, again, a very detailed, very lengthy ruling by the judge there. The judge rejected numerous opinions by the plaintiff's experts and held some key opinions, some key language here that I think sort of brings us all back to sanity regarding what a distributor's role in the entire pharmaceutical supply chain is. But the court held that there's, quote, nothing unreasonable about distributors' sale of opioids to fulfill legally written prescriptions. In other words, distributors don't have a duty to look beyond the prescriptions to see why the volume of prescriptions is what it is. And the court also found that the distributor substantially complied with obligations to track and report suspicious drug orders. So the plaintiffs in that case, the city of Huntington and the Cabell County Commission appealed in August. A briefing order was just issued last month. And so there's more to come on this one. But for now, there's at least one good decision out there in the opioid litigation. Next is James versus Medtronic. This is a drug case, a device case arising from the use of a spinal cord stimulator, which is a class 3 device. The allegations there were that the stimulator malfunctioned and caused a hematoma, which led to the plaintiff becoming paralyzed in his legs. Medtronic filed a motion for summary judgment based on preemption, and the court granted summary judgment on the preemption basis on failure to warn claims, finding that the alleged failure to warn of increased risks associated with taking blood thinners and also using the spinal cord stimulator were preempted, and that Medtronic didn't fail to report adverse events. And that's a really nice decision because on the adverse events issue, because that has been one way that the plaintiff's bar has tried to get around preemption by claiming that the manufacturer of the drug or the device failed to report adverse events to FDA. And so FDA didn't know about the need for a label change, or that there was newly acquired evidence or information that would support a label change. So some good language there. The negligence claim survived summary judgment in that James case, but it was kind of an unusual factual pattern. The Medtronic sales rep had adjusted the settings for the stimulator in the parking lot before the surgery. And it just seems that that's sort of a one-off thing. The good parts of that decision are the ones that are more likely to be repeated in future litigation. And so it's a helpful decision in that way. Okay, and moving on now to the MDL update. We talked a little bit about Zantac already. I'm also going to talk about the Valsartan MDL and the newly established Tylenol MDL. So in Zantac, in light of that recent fantastic Daubert decision for the defendants, plaintiffs really have a tough road. They had, prior to that decision, filed cases in state courts in Illinois, California, Pennsylvania, Delaware, New York, and New Jersey. I think they're likely to focus their attention in those cases. Illinois may be a big one because there isn't really a general causation element in a product liability claim. But I think given the treatment that Judge Rosenberg gave to some of the experts, which was that they don't have the right operating procedures, that they manually changed the evidence, that they didn't apply science in the same way that a careful scientist would, I think that the plaintiffs are going to have to come up with a whole new stable of experts, which is maybe a difficult hurdle for them. It certainly will be very costly. Though cost does not seem to be a deterrent for this plaintiffs group. And the other thing to point out here is that Judge Rosenberg's Daubert decision is almost certain to be appealed. And the 11th Circuit hasn't had, there are some other decisions from the Zantac MDL that are already on appeal and have been for more than a year. That, you know, the 11th Circuit isn't moving quickly, so we're not likely to see, especially with such a detailed opinion, that fully and finally resolved for quite some time. And who knows how that plays out in terms of the plaintiff strategy in other courts. Next, sorry, in the Valsartan MDL, that is an MDL also about NDMA, and the fact that it can cause cancer, or the allegation that it can cause cancer. Valsartan is a hypertension medication, and there were other blood pressure medications involved in that litigation as well. Unlike the Zantac MDL, the claims in Valsartan are that the NDMA is in those products because of a contamination issue from a single source of the active pharmaceutical ingredient in those drugs. It is not the same theory that the metabolism of the drug in the body creates the NDMA through a chemical process, or that storage conditions contribute to the to higher NDMA levels in the drugs. So it really is a much smaller group of plaintiffs. The Zantac MDL had at one point over 160,000 claims in its census registry. Valsartan is nowhere near that. I think it's here we have 1,100 or so total cases in the MDL as of a month ago. That MDL was created in 2019, and it's assigned to Judge Kugler in the District of New Jersey. He has very different demeanor than Judge Rosenberg, and tends to be the opposite in terms of how detailed he is about his legal and factual findings. His decisions tend to be pretty short, and he is much less likely to dismiss claims wholesale. There are some upcoming important deadlines. He's already indicated that he'll have Daubert and dispositive motion deadlines in February 2023. And here we have the first bellwether trial is unlikely until later in 2023, but Judge Kugler has sort of informally off the record indicated he doesn't really intend to have a bellwether on a personal injury case. He has focused some attention on consumer class action claims in that MDL and also third-party payer claims, which like Zantac have also been filed in the MDL. So that's where that one stands. There's still a lot of activity to go, moving at a little bit slower pace than Zantac did. Next, I have the acetaminophen MDL. This just was formed in October of this year. The claims in these cases are that acetaminophen or Tylenol taken by moms during pregnancy contributed or caused children to have autism spectrum disorders or ADHD. The early cases filed were focused on retailers like CVS and Costco. Some of the big retailers, 9 of them were initially named in the first bunch of cases. The MDL was certified on cases just against those retailers and sent to Judge Denise Coate in the Southern District of New York. The retailers argued that consolidation was premature since there were no manufacturers in the litigation at that stage. And, they made arguments that they couldn't control the product or the warnings on the product. But the MDL panel did not find that persuasive. It basically created the MDL on the basis that of the plaintiff's common allegations that there were neurodevelopmental disorders caused by acetaminophen's in utero impact. So consolidation was warranted. The cases went off to the Southern District of New York. This is just showing you sort of the molecular schematic for acetaminophen. It's very widely used, and I think, many women will tell you that is the one thing they were told they were allowed to take during pregnancy. And so I think also probably pretty commonly used during pregnancy, which might be part of the appeal for the plaintiffs here. They have or plaintiffs counsel, they have a large pool of plaintiffs to choose from. The sort of general background on the science here is from a few studies, and I'm not going to read this whole slide to you, but if you take a look here, these studies are very high level. So children with the highest levels of acetaminophen metabolites at birth had the highest risk of neurodevelopmental disorders. Children exposed to Tylenol during pregnancy were more likely to have autism spectrum disorders or ADHD compared to non-exposed children. First of all, I question how reliable post-pregnancy reports of the use of acetaminophen during pregnancy might be. But also, I think that all of these relate to an increased risk. None of these relate to how anyone hypothesizes that acetaminophen could cause these injuries, that it could cross the placenta, that it has an impact on the fetus during a particular time of development. And none of that is answered. All of that is still up in the air. And it's easy, there are a lot of confounding factors as to exposures that children may have had in utero or post-birth that may have led to some of these neurodevelopmental disorders, not to mention a myriad of genetic confounding factors. I just think the science here, as it's been laid out by the plaintiffs in their complaints, is really weak. So, perhaps it will develop. I'm sure FDA is looking at it now. But at this stage, we just know so little about it. There's been other litigation involving ASD and neurodevelopmental disorders due to in utero exposure to different drugs. And that science was held to be unreliable, but it was far more developed than this. There were actually hypotheses about mechanisms of action and all that sort of thing. So to me, this just seems like it has a long way to go on the science. So just a timeline here. In June, the plaintiffs began filing lawsuits around the country against the retailers, as I mentioned. And their causes of action were failure to warn, negligence, breach of warranty, negligent misrepresentation, and violations of consumer protection laws. Pretty much the usual things that we see in litigation involving pharmaceutical products. And as I mentioned before, on October 5th, the JPML centralized the 18 initial cases in the Southern District of New York. As of November, when I created this slide, when I last looked, there were 98 cases in that MDL. So the creation of the MDL has spurred additional filings. And one of the interesting things about this litigation, as with Zantac, is that this product is an OTC, an over-the-counter product. So while there may be a large pool of potential plaintiffs because the product is readily available and commonly used, plaintiffs will likely have difficulty proving product ID and what manufacturer's acetaminophen they used and the extent of their use of the product. So did you take it once during pregnancy? Did you take it 5 times during pregnancy? It's not quite the same as the prescribed medication where there are pharmacy records reflecting, consistent use of the medication. Of course, there are other ways that plaintiffs can prove their product use, including client affidavits or testimony, retailer receipts. If they did mention it or discuss it with their obstetrician, that would be, and it was noted in the medical record, that would be considered pretty good evidence as well. So that is one of the primary defense arguments would be no product ID or product use or not significant enough use to cause an injury. Certainly, as I mentioned, based on the state of the science, the defendants will argue that there is no general or specific causation. Even though acetaminophen is an over-the-counter product, there are preemption arguments to be made there. One was made by the retailers early in the MDL and has already been rejected by the MDL judge, but there are other ways to argue preemption still to come. And personal jurisdiction could be an important factor for manufacturers who did not make or ship their product in particular states. Okay. Moving on now to excessive verdicts and the factors that impact them. One of the highest verdicts this year, or some of the highest verdicts this year, were in the 3M hearing loss MDL. So that relates to the combat earplugs that were given to veterans and allegations that they were effective, leading to hearing loss or tinnitus. There have been 16 bellwether trials in 2021 and 2022. The first bellwether in 2021 took 165 hours, 22 days for that trial. The final bellwether in May of 2022 took only 9 days of witness testimony. And just as a side note there, I put on the slide that Judge Rosenberg was a visiting judge presiding over that trial. She's also the same judge that gave us the Zantac decision. And I don't know that that's why it was shorter. I think there were some just practical considerations that led to more severe time limits on that trial, given the number of bellwethers that had already taken place in the litigation. I think each time they got a little bit shorter. Okay, so we're now to our audience participation question. Considering the series of those 16 bellwether trials that took place over the 2-year period, has the amount awarded to the plaintiffs increased or decreased over time? Generally speaking. We'll just give that a second. Okay, there you can see 89% of you said that it increased over time. And if you stop sharing, we'll go to the next slide. you will see that you are right. There are a few defense verdicts in there, and I don't want to take away from the importance of those in the bellwether process, but of those where there was a plaintiff's verdict, you can see the amounts basically went up over time. There's been about 300 million awarded in the 10 plaintiff's verdicts. Oops. Sorry. And some of the factors that I think are playing a role here in excessive verdicts. First, I will say in the 3M litigation, I do think the fact that the plaintiffs are veterans plays an important factual role to some plaintiffs. The idea that 3M misrepresented risks or knew about risks and didn't share them with those who are serving our country, I think is a very big factor for some jurors that may not be relevant in other cases, but that, you know, notwithstanding that fact, we have seen verdicts getting higher and higher over time, or it just seems like you constantly are hearing about these nuclear verdicts. So some of the other factors that are more, translate more across the board include tort reform rollbacks. Some states have over time rolled back caps or exclusions on certain kinds of damages in cases. Also, class action lawsuits and third-party litigation funding. The third-party litigation funding, I just think, has led to the increased cost of litigation overall. Not so much the excessive verdicts, but maybe it lets some cases get to that point where they get an excessive verdict because the plaintiff's lawyers don't have the same amount of skin in the game. It's no longer their finances that are bankrolling everything and their personal financial risk on the line, because they get so much third-party litigation funding that really takes the pain away from a defense verdict. It takes away some of that risk. It makes them more likely to roll the dice on a trial and to spend more money getting ready for that trial. So I think it just lets the plaintiffs make some, what maybe are some, what we would have previously considered financially irresponsible decisions on behalf of their clients. But, you know, you make enough of those, sooner or later, you're gonna hit the jackpot with a jury. And finally, the final issue here is the multi-million and billion-dollar verdicts that you hear about so often in the news are sort of desensitizing jurors. It no longer seems shocking to hear somebody getting, you know, a 10 or $15 million award because that's so frequently reported in the news and it seems to be kind of normalized. Okay, looking forward to 2023, and I'm sorry, I will go a little bit faster because I know we are running out of time and I don't have much to go. Just three things to cover. One is the Mallory versus Norfolk Southern Railway case, which is pending before the U.S. Supreme Court. And the second thing is the changes to Federal Rule of Evidence 702. Quick audience participation question. Does the Federal Due Process Clause prohibit a state from requiring a corporation to agree or consent to personal jurisdiction in order to do business in that state? And if there are non-lawyers in the crowd, I know this might be a little high tech, but just play along for fun. This is the issue currently before the Supreme Court in the Mallory case. Okay, I think we're sharing the answer there now. It was about 50-50. 10 of you said no, 8 of you said yes. So if you stop sharing that, I will go to the next slide. In Mallory, the issue came up from the state of Pennsylvania. Pennsylvania has a statute that requires a corporation to register to do business in its state, and in doing so to consent to personal jurisdiction, general jurisdiction, which is all-purpose jurisdiction, meaning if you are registered to do business in the state of Pennsylvania, you can be sued there for all purposes, regardless of whether it's related to the business you have done in that state. The Norfolk Southern Railway obviously is, as a railroad, it's not super easy to pick up rail lines and move them elsewhere if this decision goes against them. They had to be registered to do business in the state. They were sued there in a lawsuit that was unrelated to their business in the state of Pennsylvania. And they alleged that there was no jurisdiction. So that issue has come, it was argued before the Supreme Court on November 8th. We'll likely see a decision on that in the spring. But it's something to be aware of if other states start passing similar statutes. Some do have similar statutes. Pennsylvania is particularly stringent about it. But something to sort of plan your business around if you can, whether you want to register to do business in every state and therefore make yourself eligible to being sued there, if that's the way the court comes out. I don't think it will, based on prior personal jurisdiction decisions from the court, but you never know. And finally, I'm going to fly through this one. Federal Rule of Evidence 702 is being amended to make it more in line with Daubert, but as the notations to the amendment say goodbye to calling them Daubert motions and call them Rule 702 motions going forward. And there's how the rule was amended, that preponderance of the evidence standard was inserted, and also that the expert's opinion reflects a reliable application of the principles. So it's changing the focus here from was the method reliable to does the conclusion support the idea that the expert applied the methodology reliably. Puts a little more focus on conclusions, forces the court, or at least the intent here is to force the court to really exercise its gatekeeper function, to really consider both the method, the reliability, the general acceptance in the scientific community of the experts' opinions. I think that the Great Zantac decision has been partly a result of an increased focus on the court's gatekeeper function. Certainly Judge Rosenberg was an excellent gatekeeper there. And, there's some stats in here about the prior misapplication of Rule 702. 2/3 of cases didn't mention preponderance of the evidence, and 13% of the cases, the judge described Rule 702 as favoring admissibility, sort of demonstrating a judicial bias towards admissibility. It'll be interesting to see if this changes how courts apply the rule. Technically, they should have been applying the standard all along, but sometimes increased focus and awareness brought about by the amendment to the rule creates a little bit different level of care and intellectual rigor exercised by the judges. So it should be a good development for defendants. Finally, I just have one regulatory update, and it is on automated external defibrillators. And it's really not a huge update here. It's really just that FDA has announced that it intends to enforce its prior rulemaking. So if pre-market approval is required for new and existing AEDs and their accessories, in April of 2019, FDA started sending letters to AED manufacturers which failed to submit a PMA, reminding them that they can't market the products. And in 2022, over this past year, FDA has put out guidance reminding manufacturers that they must file a PMA, even for previously cleared AED accessories, and sent warning letters to manufacturers who failed to submit those PMAs. They've also listed AEDs with pre-market approval and listed AED accessories with pre-market approval, making it easy for companies to see whether they're in compliance. So something to be aware of going forward. And that is it. Sorry to rush there at the end, but if you have questions at all, I think we're out of time, but you can feel free to call me or email me.
Yes, and that goes for Lauren and I as well. If you have any questions on anything we covered or anything else, feel free to reach out to us. We apologize we didn't leave enough time for questions, but thank you, everybody.